Lords is there. But if your lordships have the note, my lord, I was at page 14. I had finished, my lord, the first part of May 2013. In the sense that, my lord, this incident of May 2013 has not been proved by the prosecution, much less, my lord, beyond reasonable doubt. In the face of, my lord, two written documents exhibited by the prosecution, which shows, my lord, that the school trip, no school trip happened to Haridwar in 2012-13. Number one. Number two, more importantly, prosecution could have well, my lord, placed corroborate. It's not some rocket science, my lord. Other students were there, as your lordships have seen. None of them examined why the IO says, no, their evidence was not reliable and inconsistent with the prosecution story. So obviously, my lord, this whole thing is riddled with doubts. So lordships asked a very pertinent question to me before lunch. Why are you laboring so much on May 2013? The incident is of Lord's August 2013, where not the allegation of 375. Lord, if it was a straightforward, honest case set up by the prosecution and the complainant, it would have been simple, my lord, that this happened. She went on 14th August. He took advantage of her. But because, my lord, the prosecution story had to be built up in a manner which gives it some sense of, my lord, foundation. Otherwise, my lord, 14th public meeting happened and 15th, it's inconceivable why, my lord, she would be called, my lord, in private. So this story, anterior story, had to be built up. That's one for 375. And second, for the purpose of roping me under 370, which is for life. And 376D.
The context of asking the question was,
Yes, my lord.
you as A1 stand on a different footing
Correct, my lord. Correct.
compared to A2, 3, 4.
Correct.
One is acquitted.
Two are acquitted, my lord.
No, out of these four, one is acquitted.
A3 and A4, Prakash and Shiva have been acquitted. The assistant and the cook.
A1, 2 and 5 are
A1, A2, my lords. A2 is Shilpi. Sorry, my lord. A4 and A5 are this Prakash and Shiva who have been acquitted.
A1, 2, 3 are convicted.
Are there before your lordships.
So you stand on a different footing vis-a-vis A2 and A3.
Absolutely.
Reason being, the horse, what happened prior to 15th, arguendo, as you said, assuming she came on her own volition.
Whether 375 happened on 15th is another question, my lord. That I will come.
She came on her own volition.
Yes, ma'am.
And it was a standalone act on 15th. Even that would suffice.
Correct, my lord. Today, my lords, I have to address your lordships
We
part
are
by
not saying that's
correct, my lord.
what
Lord,
we are saying.
Yes, my
We
lord.
are only saying
Lord, I am only
the
assisting your lords.
ingredients of the offense
Correct.
where you
Correct.
are on a different footing than ingredients where A2 and A3.
Correct, my lord. I completely bow down. My lords, today what I am arguing is not 375. I have been roped in, my lords, for 370. And, my lords, I have been given, read with 170. My lords,
We follow that.
read with 120B. Now, my lords, I want to demolish this 370
So
and
you have to
120B.
seek acquittal in all offenses.
Yes, my lord. I want a clean chit. Lord, I am a respectable figure. I have gone through an ordeal of fire and I want to come clean before this constitutional court. So therefore, my lords, I am saying this incident did not happen at all. It's a cooked up story. That's my case, my lord, and I want to demonstrate piece by piece, inch by inch, my lord, how the prosecution story goes. So I am on the first part, my lord, that is from May to August 14th, where, my lord, the 370 ends and, my lords, 15th onwards 375 starts. So I want to, my lords, take away that. So I was on the first part. Now kindly have, my lords, page 14.
You call it cooked up.
Yes, my lord.
What is the motive of doing
So that's why I come to the motive, my lord. So there are 2 or 3 aspects, my lord, which I will highlight when I end.
And it is not motive of a person who's
that's
anti you.
Correct, my lord.
he God worships you.
Yes, my lord. That's very important. That's a very
So
pertinent
why
question.
would a person
Yes, my lord.
who worships
Correct.
you have such an ill
Correct,
motive?
my lord. My lord, for the two things, my lord. I'll answer that. First, my lord, there is a lot of material on record why this was done. One is, my lord, at this age, it is not wrong to have a relationship. Not the young children, they're having some kind of a relation. It's not, my lord. But in a spiritual setting, my lord, or a spiritual thing, this is considered wrong. In normal, it may not be an offense or anything like that, sir. Just 1 second. That too with my lord, somebody who teaches at that institution, who apparently was, my lord, also in a marital life. But we are not pronouncing judgment on these things. It's perfectly normal. But when that relationship is cut and she is asked to move in a particular direction, take spiritual life, etc., etc., it is not inconceivable. I don't have to prove, my lords, this motive beyond reasonable doubt. I have to only, my lords, point out that it is possible. That, my lord, and prosecutrix herself says, parents herself says, that I told them that she should pursue a spiritual life, forget the studies. You come and join the ashram. Maybe, my lords, if your lordship had to ask me whether that was the correct advice to give a girl, I would say no. But whether that is illegal, absolutely not. From my perspective, Lord, a spiritual life is the highest life. I can tell the children that don't do this, join the ashram. Can't be illegal. Now, whether that spurned her to level the allegation is another matter. But there is some material. The second material which is available, my lords, on record, and I'm not, my lord, speaking in the air. My lord, there used to be an earlier warden, Seema Ahuja. And, my lord, there was another director called one Mr. Prajapati. Now, my lords, they were having some kind of a relationship. And, my lord, it was spread that the child born to them, Lord, to us who are outside, now this appears very, my lord, farcical to say the least. But, my lord, when you are involved in, my lord, these pursuits, this seems natural. And it was stated, my lord, that the child born to them would be the next Kalki Avatar. And he would take over the reins from, my lord's me. When I came to know of it, my lord, both of them were sacked. And there is enough material, my lords, to link. And this, the prosecutrix father was closely involved with that. It's possible, my lord, enmity, because their financial thing was cut. It is possible. I'm not saying that's maybe the only motive. But there is enough material, and I will show more, why this could have been done. But today, my lord, standing as an accused, I need to show to your lordship that the prosecution story has to stand on its own feet. 101 of the Evidence Act, if you allege a fact, you have to prove it. And that too in a criminal trial, you have to prove it beyond reasonable doubt. So, my lord, the starting point of this is the Haridwar conspiracy. How have you proved it? Prosecution has not. So that was the first part. Now kindly see, my lord, going forward, I was on, my lord's, yes, on, my lord's, paragraph 25 of my note. I have shown, my lord's, page 15. The IO doesn't call these three persons, my lord, Varsha, Harshita and Anju.
Calling them as unreliable.
Calling them as unreliable. Now, my lords, kindly see in paragraph 25. The contention of the prosecution that there was an untoward incident in May 2013 with the prosecutors. Now, this is important, my lord. Is neither found in the handwritten complaint. This is the first version. Has to have some credibility because that's the first time you're alleging. Is neither found in the handwritten complaint, 0 FIR, NGO report of 20th of August, and her 164 statement, and the examination in chief. It happens, my lord, only in the 161 statement recorded in Jodhpur on the 21st evening. And that 161 statement I have said, my lord, lot needs to be said, but I'll come to 21st a little later. But at this stage, my lord, kindly see what she says in her 161 statement, according to us completely tutored, demolished in her own cross-examination, which I have shown, that no private meeting took place. Now, kindly see, my lord, what she says as far as her 161 statement. इससे पहले जब मैं मई जून 2012 में उनके हरिद्वार आश्रम गई थी. Now let's pause here for a moment. She says she went in 2012. 2012. Prosecution story in the cross-examination is 2013. May 2012, zero, zilch, my lord's evidence, zero material. But that's what she says. But let us disregard it, my lord, that she has forgotten that it is 2013. Let's forget it, let's assume. But that is a relevant fact which the lordship will consider. मैं उनके हरिद्वार आश्रम गई थी, तब उन्होंने कमरे में बुलाकर छूने की कोशिश. Now this is not there in the cross-examination. This is not there in the cross. I've shown the cross-examination. गलत गाल पर हाथ फेरा, पर मैंने सोचा गुरु है, संत है, बच्चा मानकर त्याग किया होगा, इसके अलावा कुछ नहीं किया. Now, my lords, even if no untoward incident happened, if this incident has happened, is it not relevant factor which she should say in her chief examination or in her complaint or before the magistrate? She says it for the first time before the police, or the police have made her to say it, we don't know. So nothing in the complaint, nothing in the 164, nothing in the chief, and my lords, between that, in the police statement, this is said. Why? Because the police wanted to frame me right from May 2013. And this is demolished in the cross. In the cross, she never said this. And then, my lords, kindly see her cross-examination on this. The next item. इस प्रकार उस समय हरिद्वार में बापू से 3 बार मिले थे. इन तीनों बार जब मिले सामूहिक रूप से मिले. यह कहना गलत है कि हरिद्वार में एकांत में बापू से अकेले मेरे मिलना हुआ. मैं हरिद्वार में बापू से एकांत में कमरे में नहीं मिली थी. Now pausing here for a minute, my lord. I have shown Haridwar incident has not happened. Arguendo, that is, my lord, without any substance of the shown by the prosecution, material shown by the prosecution. Arguendo, Haridwar incident, Haridwar trip has happened. 15-20 people have met. Daily hundreds of people meet me. 15-20 students come. How would it be possible for me humanly, my lords, or in the natural course of human conduct, to pick on a particular girl when I have not met them privately, and, my lords, design a conspiracy to get this particular lady entrapped by ghosts and traffic her to me? It is not possible. Against the normal course of human conduct, 30 people, I can understand. Private may, I've met somebody, I've developed an interest. Then I design the conspiracy. 30 people, 40 people going together. That's the best case of the prosecution without any foundation. But it can't be the basis of conspiracy. And the entire conspiracy is based only on one thing, that I designed this theory that she is possessed by ghosts. You have to tell her that she is possessed by ghosts. I ask myself this question. How would I have known that she will be possessed by ghosts? How would I know that she will fall sick in August 2013? Then we have to tell her. So the conspiracy today I have conspired. My lord, it just doesn't stand to, forget about, my lord, law. It doesn't stand to reason logic. My lord, that is what my submission in para 26. Therefore, the alleged incident of May 2013, projected by the prosecution as the genesis of the conspiracy, finds no support in the earliest version on record, it is conspicuously absent from the handwritten complaint, FIR, NGO report, statement under 164, and the substantive evidence of PW5, which is the chief. The solitary and vague reference in 161 is not only inconsistent but also bitter. So different here, rendering theory of conspiracy untenable. In the absence of the alleged starting point, not this whole conspiracy theory from May 2013. Now let us test this, my lord. Their theory of May 2013, let's disregard. Let's, my lords, now come to, my lords, periods further. How this conspiracy allegedly could be urged by the prosecution. Now, my lords, if this conspiracy was hatched in May 2013, your lordships may note that from May to 2nd of August, there is no allegation that I contacted or all the accused met at a particular place or contacted by phone otherwise for the purpose of this conspiracy. May to August, complete silence. So that, my lords, I have tried to encapsulate, my lord. If your lordships have, so I can quickly move, my lords. Para 7, page 17 onwards. Para 27. Thereafter, following the alleged trip to Haridwar, the prosecution record does not reflect any contact between the appellant and any of the accused until August 2013, an interval for which no explanation is forthcoming. Further, had the conspiracy been hatched in May 2013 and the appellant had allegedly developed an interest to exploit the prosecutors, there is no rationale why for 3 months there was no step taken for this purpose. The appellant could not have anticipated that the prosecutrix would fall sick in August 2013, and on her falling sick, this rules of influence of ghost would then be applied. It is also relevant to note that this alleged theory employed that by the accused persons of the prosecutrix being in the influence of ghost does not stand to logic and normal course of human conduct. Inasmuch as if the appellant wanted to sexually exploit the prosecutrix, the accused would have directly taken advantage when she was alone instead of calling that, I have said, my lord, 3 months later. Then, my lords, kindly turn next paragraph. It is relevant to note that if the prosecutrix had not fallen ill, the entire alleged conspiracy would fail, that the conspiracy was hatched of the prosecutrix being influenced by after May 2013 itself. Then, my lords, kindly turn to 31. More importantly, for the appellant who allegedly had sexual interest in PW5 to have uncertainly waited for 3 months, this itself shows that the story is completely concocted. Even as per the handwritten complaint of the prosecutrix, states that अचानक एक दिन मुझे चक्कर आया, मेरी हॉस्टल वार्डन शिल्पी ने मुझे बताया कि मेरे ऊपर भूत प्रेत का साया है. So, as per the prosecutrix, if in August for the first time, achanak se, so it is not, my lord, that she is suffering. I can understand. The prosecution story is that she was unwell for last 3-4 months. In May itself, and it was known to me in May. Then I could have told them that I have developed an interest in her. You tell her possessed by ghost. If she herself says she fell ill suddenly in August, where is the question of linking the conspiracy to May? That's my submission, madam. Even if it is to be assumed that the conspiracy was hatched after she fell ill, there was no.
Perhaps reading Achanak in abstract.
I'm sorry, madam.
You are reading Achanak in abstract. Achanak
Yes,
meaning on that day Achanak.
On that Achanak, there is no.
Achanak does not mean Achanak in the context of May.
My lords, in the complaint, she says, my lord,
We are,
Achanak.
we are trying to understand
Yes.
what prosecution would say.
Yes, my lord. I'll try to assist as much as I can.
So that later you don't
Yes,
say
my
that
lord. Correct.
What-
Very
what could
pertinent
have
question.
been addressed in
Yes, ma'am.
it escaped your notice
Yes,
instead of
ma'am.
rebuttal.
We'll answer it straight away.
Yes, yes.
But what I was wanting to place is,
Now let's say assume a situation where conspiracy is hatched in such a way, as they may argue, we don't know, that she was administered something on that day. One doesn't know. She was administered something which on that day caused that Achanak thing.
correct, ma'am. There is no such allegation, my lord.
We don't know.
No, there is no such. Lordship, straight away answer. It's not my learned friend's case also.
Feeling giddy is not
Yes, my lord.
something.
Lord, it has to be alleged
feeling giddy is not something which you have to scheme for 2 months.
Correct, my lord. But the argument of the prosecution is that we had, my lord, conspired to tell her that she is under the influence of ghosts because she was unwell. How will I tell somebody that he is under the influence of ghosts? Because she's unwell, she's falling sick. That is the story which is set up. It is not the prosecution story that she was administered something in August, she fell ill. It is not their case. It is their case. It is their case that she fell ill suddenly on 2nd of August 2013. I am only trying to show how, my lords, this is inconceivable in logic and, my lords, reason that if she has fallen sick, it's possible, my lord, if people fall sick. But if they fall sick in August, how can you say that the conspiracy was hatched in May? I can understand after she fell sick, my lord, I'll come to the second part, that the conspiracy was then hatched. I'll come to the second part now. But I am on the first part, that is logically not tenable. Now, my lord, let us come to the second part. That, my lord, after she fell sick on second, I am going to come to that. That, my lord, sir, their conspiracy was hatched for her trafficking. Let's take their case. And this is very important because I showed paragraph 384 of the trial court record. The prosecution in the end of the trial said conspiracy starts from May, not from August, which I'm going to show, which I'm going to address to your lordships. Why? Because in August, my lord, this 2nd August to 14th August or 15th August, 14th August, there is absolutely no contact with me. Absolutely zilch contact, my lord, zero contact with me. Meeting personally, phone calls, either through, my lords, directly or through emissaries, nothing. Therefore, my lords, the charge sheet, if your lordship sees the charge sheet, the starting point of the conspiracy in the charge sheet is after she fell ill on 2nd or 3rd of August. But that is given up at the stage of final arguments, saying that it starts from May, because they are not able to establish from 2nd, my lords, to 14th, there was any contact whatsoever. Because the case was shaky here, my lord, the goalpost is shifted to May 2000, and there is no, my lords, 313 statement of May 2013. Lordships are aware of the latest judgment of the Supreme Court that you put a incriminating circumstance to the accused. May 2013 was never put to the accused. So it can never be the starting point of the conspiracy, and I don't have to even rebut it because it's not put in 313. Now, my lords, let us see the second leg. And I'll give the judgments later, my lord, that if a question is not put in 313 to the accused, the prosecution can't rely upon, my lords, the incriminating material. There's no incriminating material, but any event. Now we come to, my lord, 2nd and 3rd of August. What happens? Now, my lords, I want to straight away here turn to the statements. And I have extracted them, my lords. If your lordships have the A3 chart at page 20, what the complaint is, what the NGO report is, what the 164 is, and what her evidence is. These are for the incident, my lord, of 2nd and 3rd. So that I don't have to trouble your lordship, my lord, reading the statements on this particular part one by one. So I put it all together. Now kindly have this chart, my lord. Your lordships have this. Yes. In the note, my lord, it's page 20. In the handwritten complaint, अचानक एक दिन मुझे चक्कर आए तो मेरी हॉस्टल वार्डन शिल्पी ने मुझे बताया कि मेरे ऊपर भूत प्रेत का साया है। उन्होंने कहा वह बापू आसाराम से पे बारे में बात, that's all it says. That's all it says. So what it says is 2-3 things I want to focus on here. अचानक एक दिन, so there is no prior illness, conspiracy could not have been in May. मुझे चक्कर आया तो शिल्पी ने मुझे बताया, so immediately शिल्पी told her that you are under the influence of ghosts. And आसाराम से बात हो गया मैं बारे में no evidence led, my lord, by the prosecution that I was involved at this stage. Shilpi has spoken to me, no contact. Prakash and Shiva, the only, my lord, conduits, my lord, have been acquitted. In the NGO report, my lord, which is recorded on 20th, what is recorded is 7th August, ये रात में अचानक बाथरूम में चक्कर खाकर बेहोश हो गई. होश आने पर उसकी वार्डन शिल्पी ने उसे बताया कि उसके तबीयत ज्यादा खराब है, उसे भूत प्रेत का चक्कर लगता है. देन मिलॉर्ड्स इन द 164 वहां पे एक बार मुझे चक्कर आ रहा था तो मैं गिर गई. वहां की हॉस्टल वार्डन ने शिल्पी, उन्होंने उस दिन तो कुछ नहीं कहा, काइंडली नोट दिस मिलॉर्ड, पर बाद में मुझे कहा कि तुम्हारे ऊपर भूत प्रेत का साया है, अपने पेरेंट्स को बुलाना पड़ेगा. If your lordships were to just compare this with the handwritten complaint, in the handwritten complaint she says, Shilpi immediately said I was under the influence of ghosts. But here a time gap of 1 day is given. May not be a substantial contradiction, but there is a contradiction. That pehle din kuch nahi kiya, next day she said under the influence, but some improvement is there. Now kindly see, my lord, the 161. NGO report is on. Now kindly see the 161 statement. Well, this is before the police. Now this gets, my lord, very intriguing. पिछले 2-3 अगस्त मेरी शाम को तबीयत खराब हो गई, थोड़े चक्कर आए और मैं गिर गई. मेरे हॉस्टल की लड़कियों ने वार्डन शिल्पी को बताया. उन्होंने मुझे आराम करने के लिए कहा. मैं अपने कमरे में गई. वार्डन ने मैं सो गई. वार्डन मुझे डॉक्टर के पास नहीं ले गई. अगले दिन भी मुझे डॉक्टर के पास नहीं ले गई. पॉजिंग हियर फॉर अ मोमेंट, my lords. Now there is a gap of 2 days. In the complaint, my lord, immediately भूत प्रेत का साया. In the 164 statement, 1 day gap. Now, my lord, it goes to 2 days. दूसरे दिन भी डॉक्टर को नहीं दिखाया गया. दूसरे दिन डायरेक्टर सर, नाउ माय लॉर्ड्स, दिस डायरेक्टर सर इज इंट्रोड्यूस्ड. शरद जी ने मुझे अपने कमरे में बुलाया, जहां, नाउ दिस इज वेरी इंपॉर्टेंट माय लॉर्ड, जहां भव्या पहले से बैठी थी. सो अनदर गर्ल भव्या वाज सिटिंग, नॉट देयर अर्लियर, बट माय लॉर्ड, दिस भव्या इज इंपॉर्टेंट. भव्या के लिए आश्रम में यह प्रचलित था कि उसे भूत आता है. डायरेक्टर के कमरे में भव्या के भूत ने, नाउ दिस इज इंपॉर्टेंट, वेरी इंपॉर्टेंट फॉर माय पर्पस, डायरेक्टर के कमरे में भव्या के भूत ने भूत की आवाज में मुझे बताया कि मेरे ऊपर भूत प्रेत का साया है. पॉजिंग हियर फॉर अ मिनट, मतलब complaint says Shilpi told her immediately. 164, 1 day gap becomes 2 days in her 161. And now, my lords, what is said is that Bhavya, in possession of ghost, made an announcement as a ghost voice from her that she is possessed. So the first relay of this information is not from Shilpi, it's from Bhavya. Why I say this? So if Bhavya says that this lady, you are under the influence of ghost, and this theory of possession of ghost has been built up by all the accused, Bhavya should have been made an accused, because Bhavya was acting on behalf of the other accused, said you are under the possession of ghosts, and that is taken further by Shilpi and Sharad, and taken, this lady is then taken to A1. In fact, my lord, Bhavya is not even examined. I'll show that. Bhavya is not even examined. That is why I said, my lord, at each stage, the prosecution story raises grave doubts. Forget about, my lord, any proof. Because in the 161 statement, she says, Bhavya told me that I am possessed. Now kindly see further. कि भूत आता था डायरेक्टर के कमरे में, भव्या के भूत ने भूत की आवाज में मुझे बताया कि मेरे ऊपर भूत का साया है। डायरेक्टर और भव्या ने मुझे समझाया कि सात्विक बनो, साधना में मन लगाया कर। So who started the conspiracy, Malad? Bhavya. Bhavya is definitely part of it as per the prosecution, because she says that you are under the influence of ghosts. And फिर सात्विक बनो, साधना में मन लगाया करो। उसके बाद में हॉस्टल चली गई। उस शाम मेरे वापस पेट दर्द हुआ। दूसरे दिन डायरेक्टर ने मुझे भव्या के साथ अनुष्ठान में बैठने का कहा। वहाँ हवन व अखंड रामायण का पाठ चल रहा था। उस दिन के बाद भव्या अपने घर मेरठ चली गई।
अनुष्ठान में पूजा पाठ कराते हैं, मंत्र चार वगैरह कराते हैं, पाठ वगैरह कराते हैं।
Nothing wrong, my lord, because asking a kid to do Ramayan part, really. But she seems to be upset with this, rightly so from her perspective.
Anushtan is meditation.
Anushtan is like japa, my lord. So it's like if you do 100 times, it is 1000 times. That is. के बाद भव्या अपने घर मेरठ चली गई। My lord, from there are 2 points of view. My lord, forget about the case. 2 points of view. For some people, my lord, doing this is a sacred thing. Your illnesses may get cured. But my lords, for youngsters and maybe those who don't believe in these things, it is something, my lord, superstitious. If I'm unwell, you don't take me to a doctor, ask me to do Ramayan. It's not illegal, it's not criminal. But they don't agree to this. In so many Indian households, my lord, people, my lord, say this. Even, you know, my grandparents used to say, do Ramayan if you fall, if you are unwell, etc. There's nothing illegal, nothing sinister about it. But it may not gel well with a particular, my lords, and that's probably the starting point of this. Now kindly see further. के बाद में भव्या अपने घर मेरठ चली गई। उसके एक दिन बाद अमावस्या भी आश्रम में महामृत्युंजय मंत्र का जाप चल रहा था। मुझे पूरी रात, kindly note this, my lord. It's very condescending about a spiritual practice. Nothing wrong about it. You can condescend. You have a right to not believe in these things. But probably, my lord, that may be the reason, I don't know. मुझे पूरी रात सोने नहीं दिया गया और मृत्युंजय मंत्र का पाठ करवाया। दूसरे दिन शिल्पी वार्डन ने मुझे बताया कि तुम पर भूत प्रेत का साया है और ये बात बापू को बता दी गई है। So 2-3 major improvements, my lord, from the complaint, apart from the dates, my lord, that 1 day, 2 day, etc. Bhavya is brought in, and Bhavya, my lord, in possession of some is in possession of some ghost, and that ghost voice, she, my lords, reveals that you are in possession of ghosts. And on that day, my lords, Shilpi is not there. Only Sharad is there, is in the director's room, and Shilpi tells her on the 3rd day after this. So, my lord, this entire incident, if it had happened, would have truthfully, my lords, encaptured in the complaint itself. This police, my lord, story, my lords, is somewhat complete improvement, if I can say that. Now, kindly see, my lord, what happens in the deposition. पिछले 2-3 अगस्त को 2013 में मुझे हॉस्टल में चक्कर आए थे। शिल्पी दीदी उस हॉस्टल की वार्डन थी जिनके मेरे बीमारी का पता चला, परंतु उन्होंने कुछ नहीं किया, डॉक्टर को भी नहीं दिखाया। उसके 2 दिन बाद मुझे शरद सर के ऑफिस में बुलाया था। मुझे किसी आदमी ने आकर कहा था कि आपको शरद सर के ऑफिस में बुलाया था। तब मैं वहां पर गई तो वहां शरद सर और शिल्पी दीदी पहले से बैठे हुए थे. Lordship will mark this, my lord. Again, an improvement. When she says in her 161, Shilpi is not there. I've shown that. Only Sharad is there. Mention of Sharad is there. Shilpi is not there. So now, my lord, Shilpi is sought to be roped because they have to somehow link this whole thing to me. शिल्पी दीदी पहले से बैठी हुई थी. इनके अलावा वहां पर भव्या भी थी जो हमारे गुरुकुल में ही पढ़ती थी और उसे हॉस्टल में रहती थी. वहां पर मुझे शरद सर और शिल्पी दीदी ने यह कहा, नाउ काइंडली सी दिस माय लॉर्ड, बोथ टोल्ड हर कि तुम्हारे ऊपर भूत प्रेत का साया है और तुम अच्छी तरह जप किया करो. फिर भव्या ने भी, प्लीज नोट दिस माय लॉर्ड, अगेन अ मेजर कॉन्ट्रडिक्शन. इन द 161 भव्या कम्स फर्स्ट, Sharad comes second, and Shilpi on the next day. Here, my lords, in the presence of Shilpi and Sharad, my lord, it is told to her first, it is reiterated by Bhavya later.
You call this as a major contradiction?
Lord, ultimately, if it's a truthful story, you just have to say.
Changes how?
Lord, you will have to see the credibility. But ultimately, Lordship will have to say, as we travel along, my lord, whether this is an isolated, my lord, improvement, or whether at every stage the prosecutrix in aid with the prosecution has improved her statement to frame. Lordship will not. This is only one part. Just opened the case, my lord. I have shown right from 161 from under cross-exam on the Haridwar controversy, and your lordships have seen this. So ultimately, my lords, when your lordship sees 375, 376, this should be at your back of your lordship's mind that how the improvements have happened and whether the story of the prosecutrix is at all credible. Now kindly see further. भव्या ने भी जोर से चिल्लाकर कहा, भव्या ने भी, so which is after. ऊपर भूत प्रेत का साया है, सबने मुझे भूत का कहकर डराया था. उस दिन तो मैं चली गई. So my submissions, my lord, on this broadly, my lord, if your lordship turn to the previous page. The previous page, my lord, which is page 18, paragraph 33. I just tried to, my lord, encapsulate what, my lord, in my respectful submission and in short the contradiction. Then I will quickly go through this. One, if your lordship sees 33.1, there is no reference whatsoever to the dates of 2nd August or 3rd August in the handwritten complaint, nor any mention the prosecutrix was declared to be under the influence of spirits on those dates. It is only vaguely alleged that A2 Shilpi had told her that she was under the shadow of ghost without specifying the date, circumstances involved. In the NGO report, does not refer to any incident said to have occurred on 2nd or August. On the contrary, prosecutor said that suddenly felt giddy. She became unconscious on 7th, which materially contradicts the earlier versions. 164, Melo. Even in her statement under 164, there is no reference to the dates of 2nd and 3rd. Significantly, she states that when she fell unconscious, Shilpi neither said or did anything at that time. She further stated later on, Shilpi told her that she was under the shadow of evil spirits. This version material difference from the complaint. Then, my lords, kindly see the 161. For the first time, prosecutor said her held during 2nd August that there was no treatment which was provided by A2. Shilpi says further on following day, she was taken to the director room where only Bhavya was present, and it was Bhavya through her booth stated that the prosecutor was on the shadow of spirit. Note what the prosecutor herself admits that Bhavya was known to the hospital or to the hostel to claim that she was under the influence of spirit. Importantly, Bhavya was never examined by the prosecution, and her statement remains unproved. Then, my lords, her evidence. I have pointed out what are the discrepancies.
So, what do you say about her non-examination?
Sorry, my lord.
What do you have to argue about her being, as per you, a material witness and yet not being examined?
Yes, my lord. According to me, my lord, she should have been an accused. And I want to show, my lords, how Bhavya is treated. It's very, my lords, important. Lords, in fact,
What's your take on?
My lord, because nothing of this happened. According to us, my lord, the girl was taken out of the hostel. They went on their own to Jodhpur. And, my lord, the incident never happened. The incident, my lord, has been portrayed, was done on the pretext of, my lord, this theory of Bhut, who has to frame me on the 15th. It never happened, my lords.
We are asking you this question
Yes,
because it was argued earlier, it was brought to our notice
Yes, my lord.
that they tried to reach out to Bhavya, and it's not easy for a witness to depose against
My lord,
Godman whom you worship.
my lord, my lord,
So, attempts were made to trace her and she just went away.
my lord, just 2-3 things, my lord. Just 1 second. My
There
lord,
is a certain fear factor
yes, my lord, just
of
2-3
a
things.
juvenile.
2-3 things, my lord. I can understand that she did not. One thing is examining her as a witness, as a prosecution witness. Question is that if the prosecution story is, and as per her 161 statement, that is her story, that Bhavya told her that she's under the influence of ghost. Forget about examining her, my lords. She should have been made an accused. She should have been made an accused because that is the starting point of the conspiracy. Shilpi, Sharad come later. Why is that particular person, my lord, dropped? Because if that person, her state, I want to show her how, as far as Bhavya is concerned, that untraceable is all again cooked up story. But 2 years investigation went on. Supplementary charge sheet, my lord, is filed in July of 2015. Till that time, they say she's untraceable. And in that, my lord, a lot of things have happened. In fact, the father, my lord, has given affidavits to the trial court, written to the courts, my lord, that this IO is pressurizing us to repose against. All that is on there on record. I'll come to that in a minute, my lord. But just to complete this narration, complete improvement in our story. Bhavya, my lord, is the starting point of the, my lord, alleged conspiracy on 2nd, 3rd, not made an accused. Why? Your lordships will see at every crucial time, my lords, where the presence of somebody would kill the prosecution case that has been dropped. So this is all later in, my lords, when you, my lord, first you try to frame somebody, and when at a cool head, my lords, after the investigation is over, you decide whom to examine as a witness, etc., etc. And you think, oh no, if this person is called as a PW, then it's finished. But when you frame a story, you obviously leave loopholes. This is what has happened in this case. Now kindly see, my lords, further. Paragraph, my lords, 34. The comparative analysis reveals material inconsistencies in the prosecutrix versions regarding alleged dizziness and claim of being under the influence of spirits. Earliest accounts, handwritten complaint, NGO report, etc., do not refer to the 2nd or 3rd incident, but only mention 2nd August. The introduction of 2nd or 3rd August appears only in later statements amounting to an improvement. Further, the person who allegedly declared her to be under the influence of ghosts attributed one stage to Shilpi and at another to Bhavya, who was not examined. Forget about making her an accused. These contradictions strike at the root of the prosecution case. Even if it is to be assumed that the conspiracy of the prosecutrix was arrived at after her illness, though it is not the prosecution case, there is absolutely no material setup by the prosecution that after the prosecutrix had fallen ill, either Shilpi or Sharad was in contact with the appellant on 2nd or 3rd of August. In any event, as per the story of the prosecution, conspiracy started in May 2013. Now, my lords, kindly see the note. The prosecutrix, my lord, was cross-examined on this. And B, if your lordship sees, I have put, my lords, the IO's cross-examination on this aspect. मैंने भूत के साया के संबंध भूत के साये के संबंध में व मृत्युंजय जप के संबंध में भव्या शुक्ला से पूछताछ करने का प्रयास किया था, परंतु वो उपलब्ध नहीं हुई थी, इसलिए उसका बयान नहीं लिया जा सका और धारा 173(8) में अनुसंधान लंबित रखा गया था. I pause here for a minute. Now, my lord, is the prosecution so lame, or is it so, my lords, ineffective, inefficient? Because they say they tried to trace Bhavya, Bhavya couldn't be found. In fact, it comes later. And that is why they say, my lords, that 170
don't know, maybe I'm wrong in
Yes,
understanding of my English, Hindi.
प्रयास
She
किया
didn't
था,
say not trace, she said
प्रयास किया था. मतलब it comes
She didn't
later.
make herself present.
प्रयास
She
मतलब
didn't show up. She won't
show
come.
up, right. It says प्रयास they tried.
मिली नहीं तलाश,
उपलब्ध
उपलब्ध मतलब मिलती नहीं तो
परंतु वो उपलब्ध नहीं हुई, मिल तो
उसे
गई,
भी उसे भी यही लिखते हैं उपलब्ध नहीं,
उपलब्ध नहीं.
मतलब this, मतलब
मिली नहीं उसको।
मतलब you can, मतलब there are enough processes under the CRPC. If a person is not attending, whose material is crucial or statement is crucial, I can always issue a warrant and say come. She might give something against the prosecution, but you had a duty to conduct a fair investigation. And this is one of the aspects of fair investigation. If the Rajasthan police is saying to the Milords in cross-examination that we tried, she's not a hardened criminal, she's just around the vicinity. We tried, we couldn't get her. And now kindly see, my lord, they say that 173(8) में अनुसंधान लंबित रखा गया था. So in the original charge sheet, what they said, they are pending 173(8), further investigation is pending. Then further question is asked, and finally, my lord, the supplementary charge sheet is filed in, my lord, July 2015. So incident is of August 2013, charge sheet is of November 2013, and supplementary charge sheet is of August 2015. So for 2 years, they tried Bhavya. Bhavya was not able to be traced. That's the story, my lord. Is it even believable? Now kindly see further. यह सही है कि न्यायालय में जो आरोप पत्र पेश किया गया उसमें भव्या शुक्ला के बयान नहीं होने के कारण अनुसंधान लंबित रखने का अंकन नहीं है. So she was asked a question. You said that the investigation, supplementary further investigation was kept pending because she was not examined. But have you written it in your 173(8)? She says no. है क्या? आज खुद कहा कि हमारी आदेश पत्रावली में है. मैंने न्यायालय में हुए अपने बयानों में महादेव आहिर, दिस इज नॉट रिलेवेंट, राइट? महादेव आहिर, लॉर्डशिप में स्किप दिस एंड देन में लॉर्ड्स अनुसंधान नहीं इसमें दैट फर्दर हाईलाइटेड पोर्शन, अंडरलाइन पोर्शन, अनुसंधान के दौरान भव्या को, लॉर्डशिप गॉट दैट आफ्टर 2-3 लाइन्स आफ्टर द फर्स्ट अंडरलाइन, अनुसंधान के दौरान भव्या को बयानों के लिए उपस्थित होने बाबत नोटिस भेजा था जो उसके पिताजी को भेजा था. मैंने भव्या के नाबालिग होने के कारण उसके पिता को मार्फत नोटिस भेजा था. भव्या शुक्ला का जन्म तिथि तथा ही क्या थी यह मैं रिकॉर्ड देखकर बता सकती हूँ. भव्या शुक्ला को, so my lords, she gets over this point of issuing notice by saying she was a minor, so I give it to the father. Then my lords, भव्या शुक्ला को जो नोटिस भेजा था वो आरोप पत्र के साथ नहीं पेश किया गया. Why my lords? Why was it so relevant that she, if my lords, the case of prosecution is that she was sent a notice, then you should have produced the notice. If you say you sent a notice and don't produce it with the charge sheet, I am entitled to draw adverse presumption under 114. So no notice was sent. I am saying that. Why no notice was sent? Because she would have demolished your story. Now kindly see further, my lord. मैंने दिनांक 27 या 28 को भव्या शुक्ला को नोटिस उसके चाचा को दिया था। नाउ चाचा, जो नोटिस पिताजी के नाम का था, भव्या शुक्ला के पिता से अनुसंधान नहीं हुआ था, इसलिए यह नहीं बता सकती हूं कि वो क्या काम करते थे। Now, Lordship, may skip the rest and kindly see the last portion of it, the underlined portion. मैंने भव्या शुक्ला और उसके पिता के नाम कोई वारंट जारी नहीं किया था। वे अनुसंधान में सहयोग नहीं कर रहे थे। मैंने pausing here for a minute, my lord. How will she know that they are not cooperating if you have not issued a warrant? You have not issued a warrant. You have not issued a notice, in fact, according to me. This is all cooked up later.
Anusandhan is investigation.
Investigate.
Yes, my lord. Cooperation will come after they come. They're not supporting you. मैंने इनके खिलाफ कोई आपराधिक परिवाद भी पेश नहीं किया था। यह मेरे को ध्यान नहीं है कि भव्या के पिता प्रदर्श 99 में खिलाफ प्रेषित किया हो, एक्सेट्रा। Lord, my learned friends want me to read the little earlier, if Lordship permit me, my lord. That's the earlier portion. After the first paragraph, my lord, after the underlined portion.
चाचा का नाम याद नहीं।
हाँ, after that, my lord, मेरे को भव्या शुक्ला के चाचा जी का नाम याद नहीं है। रिकॉर्ड पर भी वो दस्तावेज पेश नहीं किया है, इसलिए रिकॉर्ड देखकर नहीं बता सकती हूँ। मैंने यह नोटिस उसके घर भी दिया था। क्या संबंधित पुलिस थाना कौन सा था, यह मैं नहीं बता सकती हूँ। मैं वहां पर लोकल थाने पर नहीं गई थी और ना ही कोई वहां से सहायता ली। काइंडली नोट दिस, दिस इज वेरी इंपॉर्टेंट. Why will you not take the help
Where
of
is this?
No, just after that.
Where is this?
Lord, on that this area, Meerut. Meerut, मतलब.
किला रोड मेरठ।
मैं वहां पर लोकल थाने पर नहीं गई थी और ना ही कोई वहां से सहायता ली थी, इसलिए रोज नामचे में क्या इंद्रज होने का प्रश्न नहीं है। मैंने भव्या शुक्ला के पड़ोसी कुलरतन शर्मा, श्रीमती स्वयंसो के बयान लिए थे। उसका नाम याद नहीं। इनका पता किला रोड मेरठ का था। मकान नंबर ध्यान नहीं। मैंने भव्या शुक्ला के जिन पड़ोसियों का बयान लिया था, उन्हें पड़ोसियों को बयान आरोप पत्र के साथ पेश नहीं किया। The lordships are aware, my lord, if the witness or the accused is not within your jurisdiction, then, my lord, you take the help of the local police in that, and then you ask them. So no steps were taken. And all this is, my lord, set up in the cross-examination that I sent her a notice, I examined this fellow, they're not. Now, my lord, this gets further intriguing. The father of Bhavya, my lord, I don't know, my lord, how much relevance, how much weight the court will give, but it is a relevant fact which, my lord, casts a doubt. I am not saying, my lord, it exonerates me, but it is a relevant fact which has to be taken into consideration. A father of Bhavya gives an affidavit. Kindly see that affidavit, my lord, which is exhibited. It is a defense document, D99. In fact, the trial court has commented on this also. It is at page, my lord, 802 of the convenience volume. Huh?
A. 802. Convenience compilation A.
Yeah.
Exhibit.
Lord, this is exhibit D99. My God. Trial court disregards this, saying that he must have been your supporter. That's why he's given you an affidavit. We'll not look at it. I can understand that. But we are looking at the prosecution's, my lord,
Page.
fairness. I'm sorry, 802.
802
fairness in investigation or otherwise? Or is the police trying to hide something?
Yes.
The fact that the prosecutrix names Bhavya as the starting point of this Bhoot story is not in doubt. Then the simple thing would have been to call Bhavya. If she is not responding, you issue coercive processes against her. You put that in the charge sheet. The charge sheet says that notices have not been produced. No assistance was taken of any local police to even examine her. After her, my lord's interrogation, or after summoning her for recording her statement, you can disregard her. But you can't assume without her production that she will give a statement disfavoring the prosecution. If this is the stand, my lords, then the prosecution, this investigation is completely vitiated. Completely vitiated. I have shown, my lord, May 2013 is vitiated. This is totally vitiated on the starting part of the conspiracy. Now kindly see the affidavit. That I have been a follower of Sri Sant Asaram 803 and is preaching, and I have utmost respect for him. That my daughter so and so is studying in Gurukul. That I came to where FIR has been registered against Sri Asaram Bapu by so and so. Associate of Karamji, that is the father, came to my residence and told me to take my daughter to Jodhpur and make statements against Asaram on similar lines as so and so. That I refused to bow down to their illegal demands and categorically told them so and so. All girls are his daughter. They have never treated my child wrongly, and I cannot even dream of making such complaint. That those people again contacted me and gave me a lot of allurement and tried to induce me. And I take my daughter to Jodhpur and make statement. And again refused. I was threatened. Argue the demand, will be criminals, eliminate you so and so. But since we have been living in constant fear, I am getting threatening calls from Karambir and Association. But even the Jodhpur police, which includes Mukta Parikh, who introduced herself as SFA, and also a close associate of so and so, and Chanchal Mishra, also called me on a few occasions. Now kindly note this, my lord. Even if there is some element, you will also can disregard it. But now coupled with the fact that this Chanchal Mishra, IO is saying I have not contacted, I am not contactable. And there is something, the court should have summoned her, my lords, as a witness under 311. It was the duty of the trial court in the face of this. Would have been disregarded later, but she should have been called. Now kindly see further. She also called me on a few and threatened me. Right, if you don't belong, bring my daughter.
Inspector should have been called.
Yes, my lord. And serve a statement that she will implicate me so and so. Bring threat, property and liability so and so. And after Delhi, Meerut, and presently living in Delhi. People who came are bad elements. I don't understand, my lord. Now, my lords, forget the affidavit. I have sent, my lord, that this was a fit case for 311. But let's forget the affidavit. So let's disregard it because they are all my followers. My lord, they gave an affidavit. Now, my lords, if the father of this girl has the courage, had the courage to write a letter to the court, and he says that I have been threatened. Was it not the court's duty to call for him and ask him what has happened? 311. And in fact, give him protection or an inquiry, what has happened, etc. Now, kindly see that letter. It's also on record at page 805. Milords, Milords, the people of this country, my lord, have some amount of faith in the police, but they have implicit faith in the courts of this country. So in the course of, my lord, this trial, when the father writes to the court that please protect me. It cannot be lightly disregarded. You may have an inquiry and say that it is all trash. You are a follower of so and so, you're doing this. But when he comes to court, he'll also know the consequences. That, sir, if this is found to be untrue, I am in for trouble. So, when he has mustered courage to come to the court should have, my lords, looked at it. Now, kindly see what he says. Just a few days back, this is addressed to the district and sessions judge. Just
This
a
is
few
not
days
father.
back. I'm sorry.
This is not the father's
This
letter.
this is Bhavya's father's letter.
Bhavya's.
Yes, yes.
Bhavya herself.
Lord Shailesh Kumar is the father.
My
Bhavya-
name is Bhavya.
Yes,
First,
yes, my lord. But kindly see, my lord,
it's
806.
in first person.
Yes, yes, my lord. It's also signed by the father. Both, my lord. The child and the father both right.
Yes, but it is addressed in first
Yeah,
person.
doesn't
It's
matter.
Bhavya's letter.
Yes, yes, my lord. So Bhavya makes
Maybe
my case
because
much-
she is a minor, so therefore
correct.
he's.
Therefore, the father is also there.
Hmm.
Now, kindly see what they say.
Hmm.
This is to the courts.
Yes.
Just a few days back, I saw my name on TV channels
Hmm.
in relation to the case pending against Asaram Bapi. I was shocked to hear and see that Jodhpur police have submitted in court and on television that so and so. I can't read it. It was alleged in our state statement to the police that Asaram Bapu have committed so and so. I wish to say the mother and so on have great respect. Now find that we can forget it. That me and my family living under constant fear and threat. That Jodhpur police and father and his associates have been constantly pressurizing and terrorizing me to make false statements as per their so and so. I had and my family had to leave Meerut and presently are living in Delhi. So was it not enough for the trial court to at least have an inquiry and then you can trash this, saying that I have instigated it and may not castigate me. If I have set these people up, my lord, adverse inference ought to have been drawn against me after an inquiry. But not holding an inquiry in the first place.
No.
And my lord,
Is there the
yeah,
case set up by prosecution that this girl was conspirational along with A2, A3, A4?
No.
that is my
That's your argument.
yes, my lord.
Because
But-
you say that the starting point of chain is this girl.
Yes, my lord.
And therefore, there is a certain either presumption or the unfolding of the conspiracy.
Yes, my lord.
But would that mean that it was meeting of minds of A2, A3,
Not
A4
just-
with this girl?
My lord,
Or she just made a statement in abstract
just
that
one second.
made
just
an
one second.
abstract statement that, oh, I also suffered something like that.
Yes, my lord. No, I'll give a clear answer. My lord.
We don't know.
I just give a clear answer to this.
We just lose thoughts.
Lord, I am, will not forget whether she was part of the conspiracy, etc. The fact that she said that you are under the influence of ghosts, that is there in the prosecutorial story. Right, Mila? Now, whether that incident happened,
So one way to look at it is conspirational, as you say. Other could be the contributory factor
Yeah.
without being conspiration.
correct? Now, even for the contributory factor and my lord, the factum of the incident, we are looking at whether on second or third such an incident happened. Not forget about conspiracy. She may not be a part. Let's take the case against me, what your lordships are putting to. That she is not a part of the conspiracy, well. But whether this incident happened as per the prosecution, if Bhavya was called and asked,
And we are at a very nascent stage. These are only questions
yes, yes, my lord.
to unearth facts.
And there are pertinent questions that I'll be able to answer and clear your lordships without any doubt. I am only showing this to say that every fact has to be proved. 101. If you are saying that Bhavya has said that she is under the influence of ghosts and taking that cue, Shilpi and Sharad jumped onto this and formed a conspiracy with me, you have to first show that this statement was said. And if there is a third party who has seen this, as per you, why will you not take her help? Because if you had taken her help, the case would have been demolished. And as your lordships have seen, the cross-examination of the IO, no attempt was made. So that incident didn't happen. Bhavya never said like this. And if Bhavya never said like this, these people couldn't have linked me up.
No attempt, meaning no coercive attempt.
I don't know. No, my lords, I'm sorry, no attempt. Why? Because if the attempt was there, the notice sent to her would have been part of the charge sheet. I am entitled to draw an adverse presumption under 114 that if you are saying attempt was made and notice was sent, simple thing was to put the notice.
Another way to look at it is the IO in her wisdom thought that this girl who's your
Bhavya.
victim's friend or classmate or whatever,
Yeah, Bhavya, yeah.
she is not part of the conspiracy. So why unnecessarily
My lord, ultimately,
embarrass her by
but it's not-
involving her into such an unsavory sort of an
yes, my lord, but the material says otherwise, that she was
matter
pressurized.
where there is a certain,
My lord, the material suggests otherwise. My lord, ultimately, the
because
prosecution.
these are in the end also matters of privacy. No one
My lord,
wants.
I'm sorry, my lord. I can understand the stand taken by the investigator. I'm not going to touch her. I'm not going to touch her. I'm not going to call her. This stand, what your lordships are saying is perfectly, my lord, logical. But if your stand is that she is relevant, I sent notices to her. That notices are not produced on record. No coercive steps are taken or even steps to ask the local police to get her. But this is very serious. I can understand you didn't make any attempt because you think she is not relevant. But it can't be a situation where you try, you know that it is going to boomerang, and then my lords, the prosecution story according to me, my lords, has a lot of, my lord, gray areas. So this is one thing, my lord. And then kindly see the next page. Similar letters, my lord, to the highest, the parents' patrie of this country. She is putting her neck on the line. She's putting her neck on the line. I'm only saying it's a relevant fact. Now, my lords, I was at lords, page, my lord, 22. I have read, my lord, these two documents. And then, my lords, paragraph 23 of my note. Sorry, page 23 of my note. B. But just to summarize, further, Bhavya Shukla on 29th August had written a letter to district and sessions judge.
कुछ supplementary में आना था आगे हाँ है काउंसलर्स को बता दी हाँ ये मिस्टर बिस्सा हाँ इसमें ऑर्डर भी लिखा था धनंजय के पास ऑर्डर नहीं ऑर्डर है इसका ना मैं कल सर्वांश कल ही मैं वीकेंड पे केस पे से रिजर्व किया ये वो वाला केस है हिंदुस्तान पेंट वाला जो है आदमी उसमें जो मैं तैयार करना चाहिए क्या तो तीन डॉक्यूमेंट्स आई डेंट रेफर टू ऑर्डर में भी तो फाइल पे हैं ये डिक्लेरेशन पे है सेक्शन these are not on the file. Declaration. Relevant declaration. The file of the records relevant. Seen a declaration file under this section. Certificate number section 90 of the file की ये फाइल में नहीं तो दिला के कुछ अभी लगवाया कभी बैंक से बाद आएगा सर लगता तुमको दिला लेते हैं we'll hear you till 3:30 we have something else to do we'll hear you till 3:30 we have another 15 minutes another if you want to do it fine otherwise 15 minutes you can no if you ever so you can finish this part. Yes. That's what I'm saying. We have 15 minutes. Oh, you finished? That's what I'm saying. Finish this. Because your sixth onward starts at B3. So prior to that, you can. This is shown us.
No,
Then so after she also simultaneously wrote to the top other topic.
उसी ने उसके फादर ने लिखा है, तब तो फादर ने लिखा है,
चीजें
ओनली फादर,
next step.
नेक्स्ट फादर का है, नेक्स्ट लेटर फादर का है। हाँ,
You were saying parents factory and all that. All that.
yes.
Yes. We've seen it. We've seen both the letter. Then I think.
IPC
Yes. Right. Yes.
What is trafficking? And if I feel open for driving to go to have a place to stay, in front of the window I can come and stay. Then we have transfer. Next without first, think text. Secondly, using force or other form of worship. By abduction, by practicing fraud or deception, by abuse of power, by inducing including the giving or receiving of statements having control over the how much for firstly, secondly, thirdly, you won't get exactly. Not to have either of the five elements. If you not include transportation, algorithm, transfer, or receive from by transportation. If I am able to show them that none of these ingredients, and even one of those ingredients, is not satisfied with this, then you are personally technically from this. The real error, and so
Where has the prosecution tried to fit you in?
in fact, the trial is for a trial for judgment. Trial for skips A, B, C, D, E, F, and says, fourthly, you practice the fraud. and deception.
No, trial court would have fitted you in E,
No,
because you have received the person.
No, sir, the harbor. C.
Harbor to hai.
C में की है. C and fourth
C
and
is
sixth.
prosecution.
C plus fourth and sixth.
Harbor was with regard to other.
Lower court judgment.
A to 8.
there is no happening on it. So that. Now we're not, I want to say this. The trial court goes on the assumption that if 4-3 and 50 is satisfied, you come under 370.
Then the first part is not required.
That's what the trial court says. It is ex facial.
So it's either or. It's either or. Either 5 of these
Either 5
or A to E.
or A to E, but either and then firstly, secondly, third. The foundation is A or B or C or C or D. And then firstly, secondly, third.
From the plain reading, as speaking for myself, as I read it, it has to be either A to E, either of and one of the 6.
Right. Now the trial court only does not restrict itself to and. 4-3-15.
No, then it's reading it as or. Is not and trial court is not reading it as and, it's reading it as or.
The final mistake.
So if the horse of A to E, if I'm just trying to express what you are saying. What you're saying is that trial court says that the horse A to E, if you fit into any of the 6, then ingredient of 370 is made out.
I want to give. Lordship, I need that not. That, a thought for a lordship. Hello.
The thought is for you. We haven't found any. This thought is for you to tomorrow work on.
So just not time to open this tomorrow.
Correct.
So I can shoot up now or
We are taking up the other method. Huh?
तूने बुला लिया?
Yeah. Who was of Hindustan? Who was the